All right, every week we have a special guest, someone that can add value to the Millionaire Barbers Mastermind. Tonight, we have Rosezetta Upshaw. Now, y'all may think she's a beauty queen, a Barbie, but she is an attorney. That's right. She has book sense, street sense, all kinds of sense. I'm not going to talk long this morning because I want Rosezetta to introduce herself and then get right to business because we're ready to learn, Rosezetta, but we also want to know where you came from, your upbringing. So without further ado, if you could unmute yourself, we're ready, Rosezetta.
Hey, everybody. Chin, thank you so much for that amazing introduction. I appreciate you. On my screen, I still see you. Can you see me?
Yeah, we see you.
Okay.
I can see you.
Awesome. So thanks so much for having me. And I know that people are from all over the country. My name is Rosezetta Upshaw. I am an award-winning attorney. I am from California. I'm actually from the Bay, but I've been living in Los Angeles for the past 12 years. Hey, my boy, Coach Austin is in the building. I know we have so many amazing people in here. So, I like to engage with people. So I'm gonna ask y'all to put some stuff in the chat as we go along. But let me tell you a little bit about me. I've been practicing law for 10 years. I went to Berkeley for college. I went to USC here in Los Angeles for law school. I started out in litigation. So doing trials, I've done almost 2,000 trials, all sorts of cases. So I'm talking drugs, I'm talking child abuse, I'm talking domestic violence, custody battles, mental health, all sorts of cases where I'm doing defense. So I'm trying to help people not lose custody of their kids, help people not be in trouble based on, the situations and the circumstances that they're in. And so I was the president of Black Women Lawyers Association of Los Angeles, which is a big lawyer association here. And we're known globally. We have a lot of fantastic events. We have thousands of members. And something that I recognize in the legal community is that every attorney has things that they wish their clients knew ahead of time. So many times people call lawyers when things have gone wrong, when there's a problem, when there's a lawsuit, when you got served with papers, when somebody's suing you. And as attorneys, we want to help you as much as we can. A lot of times people come to court and the things that they've said and done make the case so much more difficult. And so, in our culture, we all know, I hope we all know, right? Put it in the chat if you've been taught that you should not speak to the police without your attorney present, no matter what. If anybody has heard of that, and if y'all believe that, please let me know in the chat. So that's just one little example of something that is so helpful. It makes a huge difference if you know just that little thing can be the whole difference between you going to prison for years versus not. You having to pay, tens, hundreds of thousands of dollars versus not, just based off what you said. And that's not just in criminal court. It's also in all sorts of lawsuits with insurance. I don't know if y'all know, if you get in a car accident or there's something with the insurance agency, you should not be talking directly to the insurance company because they're asking you questions specifically to get you to say stuff that they can disqualify the claim. And you don't know that. You think, oh, they're an insurance company, they're helpful, they're friendly. It's like, no, they are on the line trying to make sure they don't have to come out of pocket and things like that. So I really, really am passionate about sharing good information to help people just know a little bit about the law that can really make a huge difference so that they can avoid issues. And if something does come up, they're more protected. So I come from a family of business owners. My dad and my grandfather had nightclubs in Northern California growing up. My grandmother had businesses, my aunts and uncles all had, shops, stores, different things. So it's really, really important to me that business owners especially are protected and know enough about the law not to get caught up. And so I want to be clear, I'm not, trying to make you be an expert in anything legal. I understand, that might not be what you're interested in, but there are some things that you need to know for sure to make sure that you're protected. That comes to intellectual property, that comes to contracts, money, taxes. There's so many different topics. And I know, Sierra touched on some things with you about that also. So LLCs, corporate structure, and so on and so forth. So that's what I focus my time on now. So I recently was awarded Attorney of the Year by the Black Chamber of Commerce here in Los Angeles. So that was really, really great. I am an award-winning attorney, and Sierra and I founded Legends at Law so that we could help business owners and just help everybody. If you go to the @Legends at Law page on Instagram, there are hundreds and hundreds of hours of free information on various topics. It's organized just to help people be aware and have that exposure. And I have my friends come on, so it's attorneys from all over the world, mostly melanated, and just sharing their expertise. So attorneys that represent those insurance companies that are trying not to pay you, attorneys that do defense and prosecution, just dropping gems, letting people know this is what you need to know, this is what you need to watch out for. So I'm really, really proud of that. And it was really, really fun being able to go on live with all my different attorney friends and share that information. So I want you to know that we've got you covered. So we're going to talk about business today, but law applies to everything in life. So Legends at Law is very thorough. And if you need help, please tap in with us there. So thank y'all for the kind words in the chat. I appreciate it. So when it comes to intellectual property, there is so much confusion, and somebody in the chat was saying they like our trademark course. So thank you so much. We put a lot of detail into that course so that you can go step by step and understand how to submit your own trademark application. And why is that important? So just from a general standpoint, I know a lot of you in here are business owners. You have a brand, whether that's cosmetology or something else. If you have products, people don't realize that you can actually own your brand. Okay, so if you come to me and you say, I want to own my brand, I want a trademark, my rate is $1,500. And most people don't know that when you have different services, categories, products, those are technically separate trademarks. So that means that if you have a hair salon and then you also have a product, those are two separate trademarks for each of those. That's not one trademark. And so paying $1,500 each is not in everybody's budget. If you have a t-shirt line, if you have scarves and shirts and something else to go with your brand, that's a separate trademark. So it can get really expensive really fast, and you want to be protected. You want to make sure that your brand is owned by you. And that's just one brand. So let's say you have your salon, you have your products, you have your t-shirt line that goes, you have the scarves, that's 3 to 4 trademarks right there. And then you also have another business. Are you doing some type of trucking business? Are you doing some type of online e-commerce? Do you bake? Are you a personal trainer? Most people I know have more than one business. The goal is for us to have multiple streams, right? So most of us are pursuing more than just one business. And so then it's the same thing. In your other business, you will very likely need multiple trademarks in that business. So why am I telling you all this? Because that's why Sierra and I created this course, because for most people, you have a name that you can do your own trademark application for and not have to keep paying us $1,500 every time you start a new business, every time you create another product under your brand, and that's a separate trademark. We are so dynamic. We have so many gifts and talents within us. And so I want to make sure that y'all are protected when you're going out in the world and doing these amazing creative ideas that you have. So I am going to share my screen and walk y'all through some of the things you need to know about trademarks. But let me see who's in the room. Go ahead, put a 2 in the chat if you do not own a trademark today. Let me know.
You got a lot. You got that link so they can take that course, because that way they can save money by doing it themselves.
Yes, I will put the link in the chat so y'all can see. So I think Sierra put it on sale for $40 for Cyber Monday. So it's even further on sale for y'all. So that is awesome. Let's see.
And while you doing it, what made you become an attorney? Did you just think of it one day or what?
You know, I like being of service. I got into law because I like being of service. I like using my mind and my intellect to help people. So when I was in college, I volunteered at some legal clinics. So at Berkeley, they had some campus legal clinics, and I would volunteer. And people would come through the door with all sorts of questions and issues and cases, and we just had to do research and handle it. And so unbeknownst to me, what was happening was that some of the other volunteers were just taking the easy stuff or taking the stuff that they had done before, so they didn't have to do more research. I was taking everything. I was doing all consumer cases. Somebody got ripped off over here, immigration. So long story short, at the end of the year, I got an award. I didn't know there would be any type of award, but they were like, not only did you, do really detailed, thorough research, but you had the best client interaction. Like all the clients loved you and you really helped people. You had a lot of attention to detail. So I got multiple awards and I was like, oh, I think I'm good at this. So that's what really sealed the deal for me to actually go to law school after college. But it was definitely one of those things where I was, thinking about it and curious about it, and it worked out. I feel like it's a good fit for my personality. So let me, okay, I'm putting this link in the chat. Y'all know Sierra be retiring courses. So she just posted something saying that we're retiring this course. So please get it ASAP if you don't already have it. For the people who already have it, thank you so much. Okay, and I see a lot of 2s in the chat. A lot of people don't have trademarks. So I want to walk you through it because I want you to be confident. I want you to be empowered. It's just paperwork. You can do this. But I understand it's confusing. The way they ask the questions, the way they have the form organized, it's not very intuitive. So sometimes what you think they want is not what they're asking you for. So that's why we created this course, to be able to help people navigate it. And the course goes very, very step by step. Step 1, turn your computer on. Step 2, go to the uspto.gov website. Step 3, so on and so forth. So it's very, very detailed. And I broke it down so that anybody and everybody can understand it. So even if you feel like, I really don't have time to do it, somebody in your squad can do it. Whether it's the shampoo girl, your cousin, whoever's helping you out at the front desk, someone can help you with this. Alrighty. So share my screen. All right, can y'all see?
Yes.
Okay. Boom. Okay, so my stats again. Overview. It's so important to understand legal concepts. We're going to go over why trademarks are important, how to do your application, and some common mistakes to avoid. So let me give the disclaimer. We've already gotten into it, but all this content is presented for educational purposes only. This is general reference and informational purpose. This presentation is not intended to serve as legal or other advice. I do not warn or represent that the information in the presentation is accurate, complete, or current for any specific or particular purpose or application. The presentation is not intended to be a full and exhaustive explanation of the law in any area, nor should it be used to replace the advice of your own legal counsel. So I can't tell y'all to do stuff that I don't do myself. Disclaimers are important, contracts are important, and so on and so forth.
I have the screen.
All right, let me try again. Because it's big on my screen. Let me see. Okay, how about now?
Perfect.
Nice and good. Okay, good.
Perfect.
Okay. So the law affects everything we do in life, especially business. So my goal is for you not to be blindsided with legal issues that you didn't even know existed. So all your money, your time, your energy should be going into your business and into yourself, into your family, not into fixing legal issues. So let's get right into it. What is a trademark? So a trademark can be any word, phrase, symbol, design, or combination of these that identifies your goods or services. It's how customers recognize you in the marketplace and distinguish you from your competitors. So the word trademark can refer to both trademarks and service marks. But as you can probably tell from the words, a trademark is for goods, for actual tangible products. A service mark is for services. So again, that's the difference between doing hair, the service of cosmetology, versus your shampoo that you sell and your conditioner that you sell. That is a good. So it's a trademark on the product. It's a service mark on the service. But we use the term trademark in general to refer to both. So again, a trademark identifies the source of the good or service. It provides legal protection for your brand, and it helps you guard against counterfeiting and fraud. So you can see here, I like to use Nike as an example because it's a very strong brand that we all know. So they have the Nike, they have the swoosh, and they have the Just Do It. So those are three separate trademarks, and then they're also in combination with one another. So you know that if you see that swoosh, you know it's Nike. That's a strong brand. It identifies the source. They don't have to write Nike on it. They don't have to say, hey, this is our company. All they need to do is put that symbol up and you know it's them. The same thing with Just Do It. If you see a t-shirt and all it has is tennis rackets on it, you don't know who made that shirt. But if it has tennis rackets and it says Just Do It underneath it, you know it's Nike. That's a trademark. That's a strong brand. Okay. And so a lot of people get confused with having an LLC and having a trademark. So I want to be clear that these are two separate things. They don't have to have anything to do with one another. You can have an LLC without a trademark. You can have a trademark without an LLC. They don't need to be the same name. So I think most people are aware of the concept of having like an umbrella organization and other organizations under it. You know, you can have one LLC and be running multiple businesses. And so it's the same thing with the trademark. Each of those businesses can have separate trademarks. It can be owned by you personally. It can be owned by the company. It can be owned by a trust. There's a dozen different ways to own a trademark. So the LLC is the structure of your business. It's your business entity registered at a state level. The trademark is federal. We're talking about federal trademarks, and it protects your name, your logo, your brand in commerce nationwide. Alrighty. So why you need trademarks? So they're literally an asset. When you register your trademark, you get a certificate just like a deed to real estate. It is incredibly valued because all the work and energy and money that you pour into your business is captured in the trademark. And so to help illustrate that for you, just think about Apple. If you own that symbol, if you had the ability to take that apple with a bite out of it and put it on anything, you know you're going to sell out. You know you're going to make hundreds of millions of dollars, if not more. That's the value of the entire brand. It's in that trademark. Because they own that trademark, you can't do that. They own the value of their business. They're not sharing it with anyone. So if you create a really, really amazing brand and you don't own it, then other really smart people will say, oh, that's valuable. I want to use it. I want to profit from it. And so Apple, Amazon, Google, if you had permission to use that, if you could go out and trademark Google right now, you know you'd make money using it, however you use it. Even if you put it on the outside of your salon, this is a Google hair salon, people would be like, ooh, intrigued. That's the value of your trademark. So when you're putting your blood, sweat, and tears into your business, when you're investing money into marketing, into making your product and your service the best that it could possibly be, all that value is encapsulated in your trademark. So if you don't own that, then it's out there for the taking. So I want you, just like, you want to have the deed to your house, you also want to have the trademark for your brand, because that's how you own it. Okay, so again, the trademark provides a distinction between your brand and others, and it helps your business become easily recognized and not confused with another brand, because once you own it, you lock that down. Nobody else can come up behind you and do a hair salon with the same name, do a shampoo with the same name, because you own it. Now that is yours. Everybody else is going to have to come up with something different that's not going to cause confusion to customers. They don't get to piggyback off you. And right now, I just want to be clear that it is more important than ever to own your trademark, because there's a lot of sharky behavior going on. Just in general, the fact that we have the internet, we have this, this global network now where everybody can see and interact with everybody. That's beautiful. But it also means that you're exposed. Back in the day, if you had a really amazing hair salon in your city, then mostly just people around you knew about it. People in other states and other countries, they didn't know. Now you're on a world stage. If you're hot, if you're popular, if you are bringing in money and successful, everybody knows now. You have a website, you have a social media presence, you've gone viral. People love your product. People are talking about it. So now everybody has access to you. And so that creates more exposure, because anybody out there could now potentially be a risk to your business. The pandemic, people are at home on the computer, bored, looking for things to do. What do they say about idle hands? So there's racial and social discord. People are petty. People are trying to take advantage of other people for specific reasons. And then economic devastation with the pandemic, with people being laid off. Some people are hungry and they're doing things that, I wouldn't condone in order to try to get income and, just out there taking what's not theirs because it's not protected. So unfortunately, I'm having a lot more people come to me with those types of issues. And unfortunately, sometimes it's people that they know went behind them and trademarked their brand, trademarked their logo. And some of these people are even bold enough to try to sell it back to you, but that's a whole nother story. So just know that now is not a time to play games. There are people all over the world looking for opportunities to take advantage of financial gains. If you don't know that you need to own your brand and you're really popular, it can really become a problem, and it's a hard mess to clean up. So I want you to handle it on the front end. All right, so everybody close your eyes. Let's do a nice little thought exercise. So imagine you've gone through the entire process. You've picked out a name for your business. You filed an LLC. You got your EIN. You got the website. You got the social media handles. You paid somebody to make a beautiful logo. You told all your family and friends that you're about to launch this new brand. And then you find out somebody else already trademarked it and you can't use it. This happens more often than you think. We know to search Google. We know to search, Facebook and Instagram to try to see if we can get the name. But a lot of people don't know to also search the USPTO.gov website to make sure somebody doesn't own that trademark, because people can own the trademark and not be doing much with it. They may just be, doing something small with it. They might not even have a website. So when you Google it, you don't find it, but they got that trademark. They were smart enough to get the trademark. So now if you build an entire business around a brand name or a tagline that you don't own, they can send you a cease and desist letter. They can do all sorts of things to disrupt your business. So that's what we want to avoid. That's one of those little things you need to know. Don't just Google it and make sure the social medias are available. You need to make sure the trademark is available. Because if you're actually going to spend time and money and energy investing in this brand, you need to be able to own it. So there are state and federal trademarks. So the state trademark is issued by the state office. It's a faster process. Often it's under $100. The federal trademark is issued by the United States Patent and Trademark Office. It typically takes around 12 months and it's much more expensive. So most people end up paying around $2,000 per trademark when they're working with an attorney. The fees to do it on your own start at $250 and go up per trademark. All right, and let me check the chat. Jaxie says, I would be hurt. Girl, how do you think I feel on the phone with some of these people? Multiple hurt people. Can you mention about trademark devastation like COVID-19? Who owns that? We can search COVID-19 and see what comes up. Alan said, so it's best to seek out the trademark first. Yes. We all do the same thing. You come up with something catchy and you see if the Instagram is taken. Add one more step. See if the trademark is taken. Because if it is, you can try to buy it from that person. Just like, a website, if you have a really cool website and you really, really want it, people will pay thousands of dollars to get that, .com that they want. And you can try to buy somebody's trademark, but it's really not smart to move forward with a brand when somebody else owns the trademark. Like the more you put into it, the more leverage they're going to have, the more they're going to drive up the price if they're smart. Karen says, do you have to have both state and federal? No. So federal applies to every state. State applies to just that one state or however many states you do. So it's really, really important to get that federal trademark because, again, most of us are doing business internationally, globally, at least across state lines. So you want to be protected all over the nation, not just in your state. So the value of the federal trademark is a lot higher. So we are focusing on federal. Sometimes people will want to get the state just to start with something, and that's okay. But once you submit your application for the federal, you are first in line to get it. So typically, most of my clients, they just go for the federal, even though it takes 12 months. They just go for the federal. And people ask, why does it take so long? So again, it's very valuable. They are not handing these out willy-nilly. It is very valuable to be able to own a trademark, own a brand. You can literally create, billion-dollar brands with the things that you do, the actions that you take, the investments that you make. Like, recognize that all the brands that you love, whether it's Nike, whether it's Tesla, whether it's, I don't know, put some of y'all favorite brands in the chat. What are your favorite brands? I just want y'all to recognize that they all started exactly where you are. Uggs. So somebody wrote UGG on a piece of paper and was like, I'm gonna call my business, it's Fashion Nova, Beats by Dre. These all started off as an idea. Ooh, I'm gonna get the website. I'm gonna create a logo. I'm gonna create a business. Nike. Nike was nothing before Jordan. Nobody cared. Nobody liked the shoes, they didn't care, right? And now it's a multi-billion-dollar business. Adidas, same thing. So all these companies started exactly where you are. It's just a word. Sony. It's just letters on a page. So you may think, oh, it's not that important. No, nobody cares. No, when you go from 0 to 60 because, you know, Rihanna loves your product and she put it on her website and now you're doing some type of collaboration with Fenty, don't go run out and try to get the trademark then, because I promise you someone's going to be on you. You want to own it now. You are going to be successful. You need to own your trademark. And even when you're still at an early phase, when we're talking about, you know, getting investments, we're even talking about getting funding from banks. They want to see that you own your trademark, that you take your business seriously. That's the number one way I can tell if somebody really takes their business seriously, because like, do you actually own this name, this concept that you came up with? Did you take the time to actually own it? Or are you just out here, you know, not worried if somebody else takes it? That's how I can tell. And same thing, banks, it makes a difference with your credibility. So I want to tell y'all a story. We love story time about Apple, because even big companies get it wrong, right? Not everybody has me and Sierra and Legends at Law in our amazing trademark course. So Apple didn't have our trademark course and they messed up one of their trademarks. So years ago, Apple went out and got the trademark for App Store. So everybody, please put in the chat, what do you think App Store stands for? How do you use App Store? App Store. Yep. Buy apps. Application store. Download apps to buy apps. Yes, that is correct. That is exactly what everybody on the planet uses App Store for. Apple trademarked it to mean Apple Store. They didn't tell anybody that. They didn't build any type of brand or product around that, so nobody uses it like that. So basically, when Google and Microsoft and all these other companies started using App Store to mean application store, the way we all use it, Apple said, hold up, I got the trademark. Y'all can't use App Store. We own that. That's ours. Only Apple can use App Store. Y'all got to use something else, right? So it went to court. And basically, Apple lost, because the law says you have to actually build something around your brand. The reason why the federal government takes 12 months or more to give you that registration certificate saying that you own this brand is because it's very serious. We don't want people to just come up with a bunch of cool names and go trademark them all, and now nobody else can use it. You'd be surprised how often multiple people have thought of the same really cool, unique name, right? So the law doesn't want people just locking up every cool slogan, every cool logo, every cool brand, and then not doing anything with it. So if you trademark something and you don't build a business around it, if you're not actually engaged in business, you can lose that trademark. It can become void. So that's what happened to Apple. because Apple didn't take App Store and make something specific with it that is just related to their business. Like, this is what we built. No, they trademarked App Store, but then everybody thought it meant application store, so everybody uses it as the application store, and they lost that trademark. All right. Who wants to hear another story? So story time continues with Ruth Chris. Has anybody been to Ruth Chris Steakhouse? Put a 3 in the chat if you have been to Ruth Chris Steakhouse. Okay, it's a lot of 3s. It's been a minute. Yeah, don't go all the time, but I have enjoyed a steak or 2. Okay. So let me tell you where that name comes from, because I'm sure we've all kind of looked at Ruth's Chris Steakhouse. It's kind of a mouthful. Why is it Ruth's Chris? So Chris Steakhouse started in New Orleans, a really popular restaurant. And Chris sold it to Ruth. So Ruth, a single woman, decades and decades and decades ago, before women could even own a bank account without being married. So a long time ago, this woman built this really, really successful restaurant called Chris Steakhouse. She blew it up. She made it so popular. People were coming from all across the nation to New Orleans to eat at Chris Steakhouse. Very successful. Kudos to Ruth, right? So then about 10 years later, it burns down. Her restaurant burned down. Might have been some haters, I don't know, but her restaurant burned down. All right. But again, she was doing good. So she was like, don't worry about it. I'm gonna open a new location. We're gonna get it cracking again. Chris Steakhouse is gonna be right back up. Don't worry. So then Chris pops back up and says, oh, no. Let's be clear. I sold you that one restaurant. I didn't sell you my name. I own my brand. I own Chris Steakhouse. You do not have permission to reopen it somewhere else. So go do what you're gonna do, but you're not gonna use Chris Steakhouse, right? Probably some haterade in there, right? Single woman holding it down for herself and her kids. Chris, was just like, no, good luck. So perfect example of why you need to actually own your brand, because people are coming across the nation looking for Chris Steakhouse. So if she can't use Chris Steakhouse, this is before the internet, this is before, big marketing. How are people going to know that this is the same owner who now moved to a different location and different name, but it's the same quality? She was out of luck, right? So she was clever. She said, okay, you're not gonna let me use Chris Steakhouse. That's cool. It's not cool, but it's cool. She made Ruth's Chris Steakhouse. Right? It was just like, come stop me. This is what I'm doing. So she got away with it because the law was not specific on that yet. So now, soon as she did that, now the law is clear. You cannot do that. You can't make Ruth's iPhone, Ruth's Google. That's no longer allowed. But because she did it before the law caught up, she gets to keep doing it, right? So that's why the name is Ruth's Chris Steakhouse. It was Chris Steakhouse. She didn't own that brand. She didn't have a trademark for Chris Steakhouse, so that was taken from her. So she put her name in front of it. That's why it's called Ruth's Chris Steakhouse. So just a little bit of trademark law history for y'all. And a cool story you can tell to your friends next time y'all are eating some steak. All right, let's keep going. So far, Any questions? I see one question in the box. Do you trademark the name itself and the logo? Great question, Zandra. You can do both. They are separate trademarks. So typically what I have my clients do is start with just the trademark for the name, not the logo, because the name gives you the broadest protection. You can put it in any color, any logo, you know, any type of look that you want. When you trademark the logo, it's just that logo, right? So going back to the Nike example, when they trademark Nike and it's just Nike, plain letters, they can do that however they want. They can put Nike in different colors, and different shapes, different sizes, but with the swoosh, it's just a swoosh. You know, it has to look exactly like that. It can be bigger or smaller, but the proportions need to be the same. If it's art, it's the exact same logo that's protected. It's not the words. So if you have a logo that says Nike in the swoosh, when you trademark that swoosh with the Nike in it, you've trademarked the swoosh with the Nike in it. You haven't trademarked Nike. So somebody else could make that different and have Nike in a different way and arguably get away with that because you don't own Nike, you own that swoosh with Nike in it. Those are two separate things. So I often have my clients start with just the letters because that'll give you the broadest protection. So when you own Nike, you can put it in a swoosh, you can put it in a tennis racket, you can put it in a basketball, you can do whatever you want with it because you own those letters, that combination of letters. If you trademark the logo first, you only own that logo, those colors, those shapes, that look, that font. You don't own the letters. So somebody else could say, oh no, don't worry, it's not gonna be confusion because theirs is in a swoosh and it's black and white. Mine is in a globe and it's yellow and green. And the federal government said, yeah, those look completely different. So even though it's the exact same word, it's two different logos. Those trademarks can both exist as long as the main consideration is it going to confuse customers? All right, I'm popping up the chat. Did copyright instead of trademark. Victoria says, hey. Oh, wait, no, I started at the top of the chat. Let me scroll down to the bottom. All right. And it looks like there is a question box. So if you could put your questions in the question box, that helps them stay organized. Okay. Copyright and trademark are not the same. So trademark is specific to the source of the item. Okay, so whether that's a service or a good, the trademark is the source. The copyright protects the art, like a body of work. So you would copyright your book. Okay, so if you're Millionaire Barber, that's your brand. You can copyright Millionaire Barber. If you write a book, the contents of that book is going to be in copyright. So you want to trademark the brand, you want to copyright the contents. So when you're creating designs for different t-shirts, each of those designs can be protected under copyright. But the name of your t-shirt line, that's a trademark. So people often get confused with that because, again, a lot of times you put your brand on a shirt. That's perfectly fine. But the source of the good is the trademark. The contents is the copyright. So the copyright just says, you know, I am an artist, I created this, and I want the rights to it. Trademark says this is the brand that customers and clients are going to associate my product or service with. Okay, and let me see what else is in the question box. How much is the yearly fee? So to file your application, it's going to be at least $250, $250, $350, depending on how many how you structure your application, and how many trademarks you do. And then it takes about 12 months because the federal government is taking their time, making sure that you should own this, making sure that they're okay with you locking this down forever, potentially, before they give you that trademark. They're doing their own searches. They're looking at different databases. They're Googling as well to make sure that there's no confusion in the marketplace. If they give you this piece of valuable paper that says you own this brand, is that going to disrupt somebody else's business or some other confusion in the marketplace? So it's not a yearly fee. You have to prove that you're continuing to use the trademark, typically every few years. So that can be up to like 5 years. And sometimes there's a fee associated with that. It just depends. Can you purchase the name if you purchase the business and have it in the contract? So again, I don't know the details. You always want to search and see who owns the trademark. So I'm going to do that live for you so you can see how that goes. So I don't care what they put on the piece of paper. I don't care what they tell you. Don't be another Ruth's Chris situation. If they're selling you, hey, you can have my restaurant. It's called Chris Steakhouse. Okay, run me that trademark. I also need the trademark. Who owns it? Oh, no, it's part of the package. Yeah, no, it's a certificate. Yeah, run me the paperwork. Give me the actual deed. Give me the certificate of ownership to what I'm buying. And so I'm going to show you how to search and see, because it's public information. It'll say, who owns it. It may be an LLC, so there may be some layers of anonymity, but there has to be an owner attached to the trademark. What about entertainer's name? Yes, so sometimes entertainers will get their name trademarked. USPTO.gov. And we're going to go over that. That's the website, the federal government website to search the trademarks. You don't need to go to any type of paid service, any type of middleman. You can search it directly. And I'll talk about, search strategies. Of course, we go in detail with the course, but, you do want to know how to search and what the results mean. Okay, all right. So let's move forward. Pandora and Pandora. Well, would you look at that? These are both trademarks. How do they both exist? They're the exact same name. The logos aren't that different. You can barely tell which is which. It's not like they use really different logos. The reason both of these trademarks are allowed to exist is because they're in different class categories. So there's 45 different class categories. 34 are for products and 11 are for services. And this is the number one reason applications get rejected, for being in the wrong class category. So you may have heard of office actions. When you file your application, you may get an office action back. That's a federal government attorney, asking you for clarification, asking you to modify your application, asking you to provide more information, and so on and so forth. And a lot of people get intimidated by that. And that's typically when they call me and say, Rosetta, I tried, just let me pay you, do it for me. And I still try to get people to do it themselves because I want them, to feel empowered, but I often end up just doing it for them. So when you are in the wrong class category, they don't give you a chance to fix it. Typically, they just reject your application outright and you have to start from scratch. It is very important to make sure that you are in the right class category on your application. So this is one of the most important components of your application, because the classes are not clear all the time which one it should be. There's maybe it could be that one or it could be this one. I'm not sure which one it is. That happens a lot. So in the course, we go in detail about clues and tips on how to make sure you're in the right class. And Let's see. Does everybody know what this logo is? Put it in the chat if you know exactly what company uses this logo. And, you know, it's a global brand, so everybody got it right. When you see a mermaid busting it wide open, you know it's Starbucks. That is a very strong brand. So this picture is another component of your trademark application, your specimen. So again, the federal government wants to make sure that you're actually using this trademark. Don't just try to lock down every cool thing you can think of. Show us proof that you actually use it. This picture is proof that Starbucks uses the mermaid logo in the course of business, right? So typically your specimen is a photo or screenshot showing how customers see your brand or your logo as they interact with your business. So this is a good specimen. A better specimen would be if you could actually kind of see what was in the box and you could see that it was coffee products or something. But having your logo or your brand on your packaging is a specimen. Having your logo on your website is also a good specimen. So right here, this is a website, it says Pexels, right? So if the brand is called Pexels, this is a good specimen. If the brand is called Free Stock Photos, you see this over here, this is not a good specimen. So I often try to make sure my clients, before you spend a ton of money on a super creative website that has a lot of videos and moving parts, and that's super cool. But if you want to use it as proof to the federal government that this is your brand, that you're engaged in business, it needs to be cleaner than that. You need to have your brand name at the top of your website, in the middle. It can also be in one of the corners, but it needs to be somewhere that makes it clear that this is the source. This is the company. This is the brand, right? And so if you're doing a service, you know, so like with packaging, that's often a good specimen. But if you're doing a service, you're doing somebody's hair, there's no packaging for that, right? So sometimes what you're showing is your price list, something that shows, you know, your goods and or I'm sorry, your services and your brand attached. So please be consistent. Federal government is not taking any prisoners, okay? So often I see people with a trademark application that says one thing, but their specimen says something else, okay? So this example is a brochure. It says eco-volunteering, right? So if you are filing a trademark application for eco-volunteer, do you think this is a good specimen? Put in the chat, yes or no. Is this a good specimen for the trademark eco-volunteer? Alan says yet, Damon says yet, Anita says no. All right, we got some we got people thinking different things. Okay, I've seen a lot of no's. Okay. So I see some yeses, I see some no's. The answer is no. This is not a good specimen for eco-volunteer because it says eco-volunteering. That's how specific you need to be. It needs to be exactly the same thing. Not a shortened version, not a different suffix or prefix. It needs to be exactly the same. So one example that I also see a lot is luxe and luxury. If you're trying to get the trademark for luxury shampoo, your labels can't say Lux shampoo. You can't have Lux on the website, but oh, everybody knows it's short for luxury. They don't care. It needs to be exactly the same thing. Okay? It needs to be very clear, no confusion. I even tell my clients not to even put any extra tagline, like have a very clear brand for the federal government so that you can get that trademark. And then once you get it, go wild, do whatever you want. But make sure that your specimen actually matches exactly what you're asking for with your trademark. Okay? Depending on if it's consistently used, COWSLP. It needs to be consistent. It needs to be exactly the same thing. Your specimen needs to match your trademark. So if you're doing luxury shampoo and you get the trademark for luxury shampoo, if next year you start doing luxe shampoo, that's not protected. You can do it, but you don't own that trademark. So if now Luxe shampoo becomes the popular brand and Rihanna's like, oh, I love Luxe shampoo, you don't own that. You own luxury shampoo. It has to be exactly the same thing as far as what you owned, as far as what the specimen needs to show. Alrighty, let's go back to questions. Would you receive a refund if it's done wrong? What do you think? Sharmeka, do you think the federal government is giving out refunds? Really? They are not. Okay? They are not giving out refunds. If you do it wrong, sometimes you'll get an office action, sometimes you'll get a flat out rejection. Okay? That's why it's important to get it right. That's why we made this course. We also do, Q&A sessions, and we have our email available so people can contact us if they have questions about the application as they're doing the course. Okay. Let's see. Ooh, lost $500. Yes. Make sure you do it right. What about if you simplify the name of the trademark to letters? Raquel Wilson, give me more details. What trademark are you talking about? What do you mean simplify it to letters? So I'm going to share my screen and let y'all see what the website looks like, the federal government website. It's super cool. It can be confusing though, and that's why we created the course. Please keep putting your questions in the question box in the meantime. Alrighty, so, and again, use the question box, not the chat, because it's easier, it keeps it organized if it's all in the question box. So thank y'all. Okay, look at this, uspto.gov. This is the website. This is exactly what it looks like, all right? uspto.gov, United States Patent and Trademark Office .government. So we come right here, go to test, or we'll go right here and go to searching trademarks. All right, so I like to use this one because it's a little bit more streamlined. Test is the trademark electronic search system. So this is where we search. So this is the first page you see. Trademark electronic search system test. You start right here, basic word mark search. Okay, then it takes you to this page. This is where you would enter your brand to see if somebody else already has it. Okay, and notice on every single page, they got about 20 different things you can click on. So in our course, we're very specific at what you need to focus on. So somebody put something in the chat to search. Oh, you mean like the initials? Got it. So Raquel says, what if you abbreviate the name into just the initials? That's fine. You can trademark any combination of letters, pretty much. So it's the same thing. Does anybody already have that? Shonda says, made you smile. Queen King says, hair queen. Noelette says, the kinkologist. Okay, so Instagram from Keisha. All right, let me see. All right, I'm gonna start with made you smile. Shonda Bogan, made you. Okay, so I type it in right there in the box, and we come down to this drop-down menu, and when I search, I like to start with the exact phrase. So I start with the most specific search, and then I get more general, okay? So that's what this drop-down menu provides for you. You can search for the exact word or phrase. You can search for any trademark that has all three of these, or you can search for any trademark that has one of these. So if a trademark has made, or you, or smile, if a trademark has made you smile in any combination, or the exact phrase. So let's start with the exact phrase. Nothing came up. So there's no registered trademark for made you smile. That's awesome. Keep in mind, this website is typically like 3 to 6 months off. So you can still move forward with your application. This is all the information we have. Like, of course, you're going to Google, you're going to search as much as you can, but this is what we're relying on. The federal government does not have any record of any application or any registration. So somebody could be working on the application right now. We don't know, but it doesn't come up in the database. All right. So then the next phase of the search, let's go to and. Let's see if anybody has the made you smile company or something like that. Any combination that includes made you smile. Nothing's in there. That's awesome. Okay, and then if we go to or, of course, sometimes you get a ton of results. So 52,000 and some change results of trademarks that have a U in it, or a smile in it, or a made in it. So here's what I like to do. Go back and do the same with different spelling. So change the U to a U. Make sure nobody has that, because the federal government might say, yeah, it's different, but it's a little confusing to consumers. Change the made M-A-I-D to M-A-D-E. See if anybody has that. See what comes up. So there is a made you smile with M-A-D-E. And so now let's get into some of these search results. So click on it, made you smile. So they did just the plain letters. There's no logo, there's no art, there's no font. This is a standard character mark, and you can see from right there. So who remembers the other really important component of the application? I know you all remember because you're taking great notes. It is the class category. So that's what this is right here. International Class 25. And thankfully, they give you a hint as to what that applies to. So this is a company, this is a brand. They have applied for the trademark, made you smile, in Class 25, which is clothing. So specifically hats, sweatpants, sweatshirts, and tank top for their business, right? And then look right here. You see the applicant. So who filed this application? We got the address, we got the LLC, and then you can see the date that they filed. They filed this in August recently. And you can see the filing basis. So they provide you with a lot of information, and then there's public records on the back end. So you can see their entire application if you want to. So again, when you're searching, I like to start with the exact phrase and then get more and more general. And then I also like to search different spellings of things. So even like smile, maybe try smile with a Y and make sure nobody has anything that could cause confusion for your brand. Alrighty. Let me get back to these questions. Let's see. Sean, I think I answered that. No, you don't get a refund. Okay, can we use an acronym like COW versus communicating our way? Do we need to trademark both? So you can use an acronym. You can use punctuation in your trademark, but make sure you're clear on the fact that that doesn't change the trademark, right? So what I'm saying is C period, O period, W period is the same without the periods. So they'll let you trademark it with the punctuation, but nobody else could come back and use spaces or use dashes and say, oh, it's a separate trademark. Like, no. So if you had C apostrophe O apostrophe W, they're not going to let somebody else come and do C colon O colon W just because it's different punctuation. So yes, you can trademark punctuations, but treat the punctuation as if it's not there when it comes to your search. So I searched C.O.W and nothing came up. And let me try it with the spaces, see if that changes anything. Nothing. So yeah, yes, you can do like an acronym. So that's what you guys remember FUBU. I don't know if anybody here is old enough to remember FUBU. That stands for us by us. So that is a trademark. And so look, this is, so notice how there's multiple, right? Look how many FUBUs there are, okay? So it's not that a bunch of different people tried to do FUBU. It's typically that the company has multiple trademarks. So what do we know FUBU for? We know it for clothing, right? But look at this. They also filed, there's also a FUBU filed for International Class 5 for antibacterial cleaners, soap, wipes, hand sanitizing, and so on and so forth. So this is a whole separate trademark than the clothing line, right? And so sometimes that's fun. You can search your favorite brands or your favorite celebrities, and you can see what trademarks they have coming up. So another piece of information they give you is whether the application is 1A or 1B. The difference is 1A means this is a brand that I'm using in commerce. I have my specimen ready to go to prove to you that I use it. 1B says, I don't have my specimen yet. I'm starting this trademark application because I want to be protected. I'm about to start using this. Okay. And so when you see 1B applications, you're like, oh, this is not even out yet. So you can search some of your favorite brands and see what's coming out. So if you search Apple, you see a bunch of 1B application for different, I don't know, let's say nail polish and nail clippers. You're like, oh, Apple's coming out with nail care stuff. Like you can see what's coming down the line. So that can be pretty fun if you like the law, you like searching information like that. Okay, look, there's some more information on the sheet. This was abandoned. This was a FUBU application, 1B, meaning they weren't using it yet. Okay, and notice it's the exact same applicant as the antibacterial hand wipe FUBU, right? So this is FUBU. This is the Damon John brand that we think it is. This is abandoned. So International Class 9. What is that? You don't know it off the top of your head, but that's okay, because here's a huge hint, right? Carrying cases for cell phones, cell phone cases, cell phone covers, accessories, and so on and so forth. So back in 2015, they filed a 1B application saying we're about to start using FUBU with cell phone cases. This application was abandoned. So I guess they changed their mind. All right. So there can be multiple reasons why a trademark is dead. And you can see that here in this column. Some of them are live and some of them are dead. If it's live, that just means that the application is either still pending or that it's been fully registered. So again, we go through all the details in the course on how to read the results, but this is how you do your basic search. All right, let me get back to these questions. So, is it available to use when it says dead? So for the most part, yes. If it's dead, then it's available. Part of the application and registration process is that they publish it to the public and say, does anybody have any objection? Just like a wedding. Speak now or forever hold your peace. So when you see something is dead, sometimes you're at greater risk for there to be some type of objection and someone to say, no, this is my business. I forgot to, file my fee 5 years ago, but I'm still using this business. Please don't give my trademark away. And again, when you look at the search results, you can see the dates. You can see the name. So you can even Google that LLC. You can even Google that person's name and try to see what's going on. Like, is this really dead? Are they done? Like, FUBU, like that mark was abandoned. However, I don't think Damon John is just gonna let people start using FUBU, whether he abandoned that specific application or not. If you try to register a FUBU, hand sanitizer, I'm pretty sure Damon John's gonna have something to say. So even though that mark in that class category is dead, it's available, but that doesn't mean you're absolutely going to get it, if that makes sense. Can this be rewatched? You got to ask Chin. You got to ask the boss. Most trademark lawyers I found charge $18,000 to $3,000 to file paperwork for you. Is that standard? Yes, that is standard. The lowest I've ever seen is probably like $800-900, but that doesn't include everything. So it's like, oh, we'll do it for $800, but then it's like you keep having to pay more to actually get through the whole process. So our $1,500 is a $1,500 flat rate that includes what most people need. As far as the office actions and going back and forth with the federal government, it's like we will handle some specific office actions. If it's crazy and it's a lot more work, then that will be extra fee. But for most people in a standard application, our $1,500 flat rate covers it. And of course, our course, which I believe is on sale for $40 right now, go ahead and check it out with the link, is only $40-50. Using the acronym, yep. What does it mean when you filed and in the process, can you use it for branding purposes, or what does that look like? Yes. Once you file your application, you're good. Use your trademark, use your brand, keep investing, keep moving forward. If you get an office action, if you get a response that's like, oh no, Damon John wants FUBU back, you can't make your FUBU hand sanitizer, then you cross that bridge when you get there. But typically, if you've done the search the way we teach you to do it, then you can be pretty confident in the process. So if you have a trademark where, you did the search, you feel confident that there's not going to be a bunch of objections and people trying to stop you, then definitely go forward. But if you're trying to trademark FUBU for nail polish, because Damon John didn't trademark nail polish, I would say, don't bet the farm on it, because Damon John's probably going to have something to say. Does he have to keep his filing status up? Yes, he does. Yes, he does. Is the course available to watch anytime? Yes, it is. So it's pre-recorded videos. The link is in the chat, and let me put it in the chat again. I'm sure it probably went up super high. Okay, there it is. The link is in the chat for the course. And so the videos are pre-recorded. And again, I go straight to the point. I take you straight here to the federal government website. The instructional videos are, 20, 30 minutes each. And there's, I believe, 6 of them. So it's less than 3 hours for you to understand what you need to do to file your standard application. So our goal is that you get through it and you actually do it, because a lot of people are out here operating. You got the website, you got the social media, you're making amazing content. All it takes is for one of those videos to go viral, and there will be some sharks in the water. I just want to make that clear. I can't tell you how painful it is for me. I don't even own these brands when people come to me with these types of problems. Rosezetta, someone went out and got my trademark. What do I do? You know, someone sending me a cease and desist letter. It's a hot mess. I don't want that for any of y'all. All right, let me get back to the questions. I put it in there. I can see it. Can everybody see my comments? Oh, yeah, my bad. It says host and panelists. Let me see everyone. There we go. There we go. Yay. All right, there's the link. I sent it to myself. All right, let me get back to these questions. Okay, I think, wait, no. So if it's dead or abandoned, do you have to get the dead or abandoned person's permission? No. You don't have to get permission, but I'm just saying, if it's something major, like FUBU, like a big brand, they're probably not gonna go down without a fight. So if it's Frankie's hot dogs, and somebody used to have it, but now it's abandoned, and you do your search, you can look on the back end and see, you know, exactly what happened. Did they just miss a filing fee, or did they never respond? Has the federal government been trying to get in contact with them for years and they never responded? You can do your Google search. Is Frankie's hot dog still active? And so you can get a better idea of what's going on. But when it's dead or abandoned, that means it's available. But part of the process is they give people a chance to object, and they consider the objections. Doesn't mean the objections are going to be successful, but it does delay your process. So to the extent that you search Frankie's hot dogs and you see a dead mark and you don't see anything that looks like, because again, you have the name of the LLC or the name of the person, you have the dates, you have all sorts of indications that can provide you with so much information about whether or not this would likely end up with an objection. So if frankie'shotdogs.com is a dead site, Frankie's Hot Dogs Facebook ain't had a post since 1992, you know, you're probably good to go. But if you see Frankie's Hot Dogs and the trademark is dead, but they just had a, you know, they just had a fundraiser, they just had a big new launch, they just franchised, you know, it's just like, they may have dropped the ball on their trademark. It doesn't mean they're gonna they're not going to object to you getting the trademark. So that's one of those things where, yes, you can go ahead and file the application, but just be aware that there may be issues moving forward. Alrighty, I'm not seeing any more questions. Thank y'all so much. Oh, wait, couple more questions. Can you explain 1A status again? Yes, I can. So let me get another example up here. Okay. What else did people want me to search? The Christian. Am I spelling all that right? Yes. I think I am. Okay. So I like to start with the exact phrase. Nobody has that. Let me search with any combination of this. Nobody has any combination. All right, and let me search for or, just for good measure, see if there's anything that might cause confusion. Okay, so we have 4,098 results. And so you would just go through these and make sure there's nothing that looks too similar to where a person could be confused. So far on this first page, I don't see anything that's super confusing with the Christian beautician, right? We got some stuff with "the" in it. We got Megan Thee Stallion Hottie Sauce. Don't think anybody's gonna confuse you with that, right? Let's see what's going on with Hottie Sauce. Okay, it's a 1A application, meaning they're saying that we're using this, right? Y'all saw the commercial, was it Popeyes or something? So here it is right here, first use, May 18th, 2021, okay? That's part of the application. So when you see 1A, that means this is in use. When you see 1B, that means they're saying we're about to start using it. So that's weaker. Sometimes you still might have an opportunity to slide in there because a lot of times, unfortunately, with 1B applications, people don't follow through. And so that's when you see a lot of dead marks. So let's search and see. Okay, all these ones are live. People are using, when you put 2 E's on the, you mean business. So all of these are live. All right, here's some dead ones. Okay. The Christian Single Moms Podcast. Okay, it says abandoned. International Class 9, downloadable podcast in the field of single motherhood. So this was a 1A application. Single mom started using this in 2019, filed this application in 2020, and at some point abandoned the application. It did not get registered. So who was this? This was Michelle Donnelly, an individual. This is her address. I hope this is a mailing address. One of the things we talk about in the application is don't put any address that you don't want to be public. It is public. They ask you for a domicile. They ask you for a business address. Put a mailing address for both, all right? Because I don't want your address out here. Let's see. Another dead one. Find my hairs and nails beautician. Okay, so this is a 1B application. Find my hairs and nails. Someone was like, that's mine, and I'm sticking beside it. And I am filing an application in September of 2020. So this is International Class 42, providing online research and reference services on computer networks and libraries, yada, yada, yada. Okay, so basically, this was abandoned. They never started using it. So 1B simply means I'm starting my application, but I don't have my specimen yet. But just know that you can do that, but they still require you to have a specimen before you actually get the registration. So they'll go through the whole process and say, cool, we're ready to give you this trademark, but you still got to have a specimen. So everything that's required in the 1A application is still required in the 1B application. And the 1B typically has more fees and it takes longer. So I encourage people to wait until they're actually using the trademark, even if it's the same day. Like I started using it on September 3rd, and now I'm filing my application on September 3rd. That's typically what I tell people to do if they're really worried. Like what I have is so hot and I don't want to put it out there without being fully protected. Cool. Do it the same day, do it the same week, but it's a much more streamlined process when you file a 1A application saying, here's my specimen, here's a screenshot of my website, here's a picture of my packaging showing that I use this in business. All right, next question. So if your application says 1B, it's approved. No. 1A application means I am using it currently. 1B application means I am not using it, but I'm going to start using it. So 1A application is stronger because you have all your components. DBA, I renewed it after 10 years. Is there a time limit on the trademark? LaShawn, I don't know exactly what you're asking. You can file your trademark anytime if it's available. You don't have to file it right when you started your business. Jaxie says, should we use a P.O. box address? I don't know if they let you get away with a P.O. box. You can use the hack that people use where you put the mailing address, the entire address of the post office, and put your mailbox as like the apartment number. So most of the time you can get away with that. So whatever the address is for that post office or that, mailbox service, use the full address instead of putting P.O. box, because I wouldn't want your application to get rejected off a P.O. box or get, delayed. So I would say at the very least do that. Put the address of the post office or, of the location. And then put the box as the number. Let's see what else we got. Can we use the same name for different goods? For example, one is for vitamins, the other one for music. Yes. So that's separate trademarks. So if you want to use luxury shampoo, luxury nail polish, luxury lipstick, luxury t-shirts, like it'll all be separate trademarks in different class categories that you own. Okay, let's see, any other questions? Oh, dang, Sierra already retired the course. My bad, y'all. COWSOP says the course is unavailable. Dang. All right, I'll see what I can do. Was anybody able to get it? I didn't click on the link, but it was active today. I thought she posted that she was going to retire it today. I guess she was not playing it. She meant I am going to retire it immediately. Jaxie says she got the course. Well, y'all better hit up Jaxie, see if she want to share it with y'all. Let's see, going down back to the questions. Okay, where did I leave off? Okay. Sequana. I filed one time that it's correct with DBA filing your name. It's every 10 years. Okay, I think I get what you're saying. So when you file your trademark application, it's good when you get it registered. It's not an annual fee that you pay. They'll notify you and let you know, every 5 years or whatever it is when you need to update it. And sometimes part of that update is providing another specimen, like proof to us that you're still using this. Like, this name is hot. We don't want you to lock it up if you're not actually using it. Ayana says, can I use the same logo for my salon, Spool, and product line? Yes, you can use the same trademark. It'll just be separate categories. Okay, so that's one of the things that they search for when they're deciding whether or not to allow people to do different trademarks. So again, like we saw with FUBU, there were a dozen different trademarks. Some were dead, some were live, some were 1A, some were 1B. But the fact that it's all Damon John, it's much more likely to get pushed through than if it's different people. Because number one, Damon John can object. And number two, they don't want it to cause confusion. So even if it is a separate class, technically, because again, some of the classes overlap with different things. There's only 45, there's a million different products or services that could exist. They look at who owns the other ones. So if it's you every time, then you shouldn't have a problem. Like, oh, Ayana's doing more. Oh, Ayana's doing another one. You can file your trademark, your brand, your logo for multiple different class categories. Okay, Shawan said she was able to get it. She got the course. All right. Whew. I'm gonna have to text Sierra and see. Okay, somebody else was able to get the trademark course. So y'all put the link in there one more time. I think you can get it. So the class is pre-recorded, and then we do live sessions to answer questions. So we have live Q&As, and if there's, if we're getting the same question all the time, then we do another video and we upload it. And then we upload the Q&A session so you can see the questions that people ask. So the course is at your own pace. So enjoy. Do I just go to uspto.gov for a trademark application? Yes. So trademarks, patents, to do the search, to do the application, to check the status of your application, it's all on uspto.gov. Alrighty, did I get to everybody's questions? Would the Prey brand closing be considered 3 different things, or all the same things when filing a trademark? OB Hawk, what do you think there, buddy? I use the luxe and the luxury example. Those are all different things. Would Prey brand, the Pray brand, Pray brand clothing. Those are 3 different brands. So if you wanted to be strategic, you could try to just get Pray brand and then use it in combination with other words the way you want to. But keep in mind that wouldn't protect you from other people using combinations. So Pray brand and Would Pray brand are 2 separate things. So if you trademark Pray brand and somebody else is like, I like the way Would Pray brand sounds, they can file that application because you don't own it. If you trademark Pray brand as consulting and courses, and someone else says, I want to do Pray brand clothing, that's a completely separate class, and that's a completely separate trademark. Pray brand and Pray brand clothing are not the same thing. That person would very likely be able to successfully get that trademark. So you have to make a decision on what makes the most sense for you. OB, definitely get the course. You don't have to go out and pay attorneys thousands and thousands of dollars to get those 3 trademarks and I don't know how many separate classes, right? So it could be multiple categories depending on what each brand is doing, if each brand is doing more than one thing. So if you get the course, you can do it yourself, have at it. Pray brand this, Pray brand that. It'll be, at least $250 each time, but that's a lot better than $2,500 each time, right? But yes, keep in mind, all those are different. So yes, the course is hosted on Gumroad. So you'll get the emails, you'll have access to the Gumroad course, all the videos all at once. It's not dripped out. You can go at your own pace. Again, it's straight to the point. So you can definitely do it in a day. Will we be able to help our community with trademarking as you have helped us, or do we outsource to y'all if I have clients needing this service? Alan, very happy to have helped you. Yes, the whole point of this is to empower you. Yes, you can empower others, okay? So you know how to do trademarks. People get confused about when an attorney is required and when attorney is just, advised. Okay, trademarking is one of those things. Depending on how complicated or how simple your trademark is, it may be advisable to talk to an attorney. You're talking to one now, so you're good, but it's not required. You can do your own trademark application. You do not have to be an attorney to prepare the application and submit it. Okay, you have to be an attorney to represent someone. So for me to say, I am acting on Alan's behalf, I represent Alan, that's what an attorney can do. I have that power because I am licensed to practice law, right? You can't do that without that license. It doesn't mean you can't do paperwork. The trademark is just paperwork. Now, if something goes wrong and you need to go to court and defend the trademark, attorney has to do that. You can't go to court unless you're just representing yourself. But you couldn't say, oh, I'm representing this person with their trademark because I helped them with their application, right? So I just want to be clear. And we're talking about federal trademarks. So that's why I have clients all over the world, all over the country, because it's federal law. So even though I'm a California attorney, I can practice federal law because it applies, it's the same everywhere. Okay, y'all scared me. I was gonna call Sierra like, dang, you're not playing. What makes a difference than the restaurants in New Orleans? I'm not sure. Do I just go to USPTO, double my information? It went through the 3rd time. Okay, COW, I'm glad it went through for you. I'm glad it worked out. Tron de Bowman says, I'm in. Yes, it'll be sent to your email. Thank y'all so much. I'm really excited for you to be empowered and be able to handle your own trademarks now and forever. And typically it is lifetime access. So as long as the site is up, you have access to this. So, You can always reference the videos if you file your trademark now and then you get another idea and you want to do another one, 5 years from now. Alrighty, I think I got through all the questions. Right, there's like a thingy on here so that you can check off the questions that you answered. I haven't been doing that, so all 35 are still here. Does anybody have any final questions? When the person was asked about the name and you said others could add to it, with a restaurant example, you said they couldn't anymore. Yes, okay, so there's a difference between just putting your name in front of something and using multiple words, right? So I can't put Rosetta's Apple, Rosetta's Tesla, Rosetta's, Google, Rosetta's Nike, right? Because that would very obviously be that's my name and another brand. Okay, so if I wanted to be clever and try to say, oh no, this is something different, it just happens to have my name and Apple in it. So like, let's say I did the Rosetta Apple Company. I could probably get that, but I can't get Rosetta's Apple, right? So my name 'S and somebody else's brand. That is now illegal. Roof Chris got to do it. But, federal government said, we don't like that. We don't want people running around doing that. I mean, that's smart. There shouldn't be Rosetta's Apple, Rosetta's Tesla, it's messy. And so I get it. But yes, so that's the difference. Your name 'S and somebody else's brand, especially in the same category, not gonna go. But you can be strategic. So again, Rosetta's Apple versus the Rosetta Apple Company. Even if it's in the same category, that's different enough to where they might let me start making iPhones, right? Apple versus the Rosetta Apple Company. Maybe, maybe not. So if I really wanted to, try, I could definitely try. It's different enough, but Rosetta's Apple is not different enough for me to start making cell phones, right? Especially not with a similar logo. It would have to be very, very distinctive. So when it's not a powerful brand like Apple and it's just normal words, like, what was it? Prey brand. So because Apple is so big, this probably wouldn't work with Apple, right? You probably just couldn't do Apple clothing, Apple hats, Apple this, Apple that, especially if Apple already has it. And so big companies typically have all the categories locked down just for this reason. They don't want anybody trying to be cute and come up with something similar. It's technically a separate category. Nah, we got all the categories. Don't worry about it. Right? So I'm pretty sure when we did the search, I know we didn't do the search. Let's search wood prey. What was that? Exact phrase. Nobody has it. Let's go to and. Oh, there is Pooja brand. Okay, let's get into this. What's going on here? The English translation of the word puja means pray or worship. So this is a different language, but this is pray brand. And that's part of your application too. If you have something in a different language, they want to include that because again, They don't want any confusion. If it's a word like hola versus hi, hola versus hello, they want that to be clear because that's has some overlap. So that's why Pooja brand is coming up when we search the pray brand, because technically that word means pray. So this is not a standard character mark. See, they actually have design plus words. So that is the logo that they've trademarked. So that's helpful too, because even if this was pray brand, they only own this logo. They don't own the words. So you would still have room to submit your application. You would still be very likely to be successful, and they might object. Let's see, Malik Sardana in India might object. It says India, but then it also says Virginia. All right, Malik looks like he in Arlington, Virginia. But this mark is dead, and it was filed in 1990. It was canceled in 1993. So you get a lot of background information here in the search results. But yes, the Pray brand, and what was the other one? Pray brand clothing. Same thing. Start with the very specific. Nobody has that. That is awesome. Go a little bit more general. Any combination. Nobody has any combination of pray and brand and clothing together. Now we go to or, and then we get results. So almost 30,000 people have a trademark with either pray or brand or clothing, which, that makes sense. So then sometimes what you want to do is be a little bit more specific with the main words of your trademark. So let's see if anybody has anything with pray and clothing. There's an I pray clothing. Okay. International Class 25 is closed. And this is a registered trademark. They just got this right before Thanksgiving. Look at this, the registration date. That's how you know this is a fully complete application. The registration date will be listed. November 23rd, 2021. And this is John Franklin and Christine Gonzalez. They live together in New York. They just got this trademark. They filed it in January. It came through in November. So that's almost a full 11 months. So let's see. So yeah, clothing, I pray clothing. So yeah, it comes up because it has pray and clothing in it, but pray brand clothing is different than I pray clothing, right? So they are specific in that way because, again, there's billions of people on Earth. They don't want to lock up every cool idea unless it's absolutely necessary, because it would cause confusion. Okay, POC. And again, this is a logo. This is not just the letters or the words. So POC stands for Pray Often Clothing. So that's why this came up. The name of their LLC is Pray Often Clothing. POC is the abbreviation. And this is the mark that they filed. It's currently dead. It was abandoned. This is from back in 2016. So again, if you know how to read the results, you get a lot of information. Somebody said good night. Yes, it's getting late, huh? For y'all on the East Coast especially. So thank y'all so much. I hope this has been helpful. I know we only talked about trademarks. We didn't really get into business and contracts and everything. But this is a really, really important aspect of your business journey. And I know if you're listening to Chin and tapped into his network and his teaching, then I know you're going to be successful. Chin can get you there. Chin is one of my favorite people and somebody I definitely go to for guidance in business. So thank you, Chin, for having me. I will stop my share. Go back to my face. Zipporah says, this is so good. You just answered my questions again. You're awesome. Blessing to you. Thank y'all. You know, go ahead. Let me put my little socials in here. I'm basically Rosezetta Upshaw everywhere. Check me out. Tap in if you need help, but that course is thorough. I stand by it.
Put the link in the course.
I'll put it in here one more time.
Because everybody on here needs this. Everybody. You really taught a lot tonight. You taught a whole lot.
My pleasure. My pleasure. I love to help. So Kim said, how long does it take? Typically 12 months. How much does it cost? $250 to $350, depending on your trademark. But our course is less than $50.
Well, Rosezetta, I really thank you. Make sure you all follow Rosezetta. Can you type in the chat, put your Instagram, and we need to know your theme song so we can end with the theme song. Tell me what's your hype theme song. I'm gonna get the DJ to play it.
So much pressure. What's my song? I like a lot of Earth, Wind, and Fire. Play me some or some Beyonce. Play Shining. Ooh, no, Black Parade. I got a lot of songs. Play Beyonce, Black Parade. That's my jam. Please.
All right. Everybody in the bronze and gold program, we will put this in the back office. I'm gonna stop this recording right now.